I'm delighted to be inaugurating the American Bar Association's India Conference of 2023, particularly because I also learned from what Mike said a short while ago that we could be actually wielding our jurisdiction under Article 142 of the Constitution to have a more productive association of Hawaii with India, perhaps. I've had the occasion earlier of speaking at ABA's conference in 2021, but I congratulate the organizers for bringing together leaders from across the legal community over the course of the coming weekend. So Pratibha and Ms. Chotani, my heartiest congratulations for putting together such a brilliant conference with your colleagues. As I began to think about this year's conference and its subject, which was Law in the Age of Glocalisation, Convergence of India and the West, it sort of dawned on me that in many ways, our Constitution, the Indian Constitution, is a prime example of glocalization even before we ventured into the age of globalization. While the Constitution was framed in a world which was starkly different from the globalized world in which we presently live, it is no secret that the drafters carefully reviewed the constitutions of several countries and learned from their experiences, whether it was in the context of the due process of law or a variety of constitutional concepts which have now become a part of our own tradition. The chief architect of the Indian Constitution, Dr. Ambedkar, explained the importance of global engagement in the process of constitution drafting when he said, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world." And he said that just before the constitution was adopted. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution are recognized all over the world. Given these facts, all constitutions in their main provisions must look similar. Dr. Ambedkar further added that the Indian Constitution was not merely an inspiration from the global discourse, but was based on the local aspirations of the country, when he stated that the only new things, if there can be any, in a constitution framed so late in the day, are the variations made to remove the fault lines and to accommodate it to the needs of the country. In that sense, our Constitution, our founding document, had a combination of both the global and local and produced a uniquely Indian local product. While the Constitution took inspiration from the global, the course of jurisprudence and law that it chartered was innately rooted to India. As we discuss this 7 decades later, there is no doubt that the Constitution was a transformative force in our society. The Constitution was grounded in our social and political context, while also trying to incorporate global practices. However, what has changed over these 7 decades is the fact that we are in an increasingly globalized world. Now, not only do the meta lessons flow across borders as they did 70 years ago, but our day-to-day lifestyles are influenced by the happenings across oceans. Our age has consequently led to our practice in terms of laws being more interconnected than ever before, be it in terms of data protection as we draft our law, or in terms of our jurisprudence on insolvency or arbitration. The impact of comparative jurisprudence is continuously rising and evolving. Of course, there is nothing surprising or spectacular about this journey. Rather, one of the most innate human tendencies is to learn from others. This is what has enabled our species to evolve and thrive. The extent of our being interconnected is obvious from the breadth of the topics which will be covered in the conference itself. Hence, I begin by congratulating the organizers in the manner in which they are covering over 25 subtopics under this theme. The law has, in a sense, served as a global currency of trust in our globalized world. And I borrow that phrase from what a distinguished judge of the Singapore Supreme Court, Justice Sundaresh Menon, has said in a recently published book called Transnational Commercial Disputes in an Age of Anti-Globalism and Pandemic. The book is by Chief Justice Sundaresh Menon and Anselmo Reyes. So they describe the law as a global currency of trust. Globalization has, in that sense, created a new transnational marketplace. And in the introduction to the book, Chief Justice Menon says that if legal rights can be considered the new currency of trust, then it follows that our own legal frameworks have become the national bank in which we can safeguard and realize those rights. So far, so good. But we are equally cognizant of the fact that globalization has led to its own discontent. There are a number of reasons for this. For the meltdown which has been experienced world over in democracies which were liberal and which we today may wonder whether they are liberal, especially in the context of the jurisprudence which their courts are evolving overseas. There are numerous reasons for the meltdown which took place. An anti-globalization sentiment, as it were, overseas. One, I think the first of the origins of this lay in the terror attacks which took place in 2001. India was shaken up sporadically by these terror attacks, as we were several years ago in the previous decade. But 2001 was a watershed moment which brought to the global society the stark realities which India had already confronted for years and years before that. The second, I believe, was climate change and the impact of climate change across the world, whether it is in terms of the changes in the monsoons, the changes in cropping patterns, the spread of disease, and the impact of climate change on farming communities, on fishing communities across the world, which threaten the existence of the most marginalized groups in our societies. Climate change is not something which is therefore an elitist notion, but it recognizes the impact of something which starkly faces our societies, especially communities such as those in coastal nations and coastal states, which would be seriously affected by the impact of the pandemic. The third, I believe, is the impact of the COVID-19 pandemic, which forced nations to shut their borders and to pull down their shutters. The pandemic gave rise to an urgent need to look within, close ourselves to the rest of the world as travel was restricted, as communities struggled to survive. The fourth reason for this global meltdown, I believe, is in the rise of inequality across the world. Because just as globalization produced a larger pie for nations and a reduction in poverty across the world, equally, the share of that increased pie which devolved on the lower half of the population was far less than the share of the pie which was consumed by a fraction of our populations globally. And this rise in global inequality was perhaps one of the reasons for the reaction that you face world over to the rise of not globalization, but localization movements, whether it be in terms of politics or economics or the historical evolution of our societies. As a politician in the UK said, a rising tide seems to lift all the boats. It now seems, he said, that the rising tide seems to only lift the yachts. Now, how do we ensure as professionals, and how do you ensure as thought leaders, that this assessment of globalization as rising the yachts and not the boats is replaced by a model by which it's the boats which rise? And I think that is really the challenge which we face. But I do believe that the COVID-19 pandemic gave us opportunities in darkness and discontent. Because the history of the human race lies in our ability to rise above discontent and to see beyond darkness, even if we cannot see within darkness. And COVID-19 really was, in that sense, a game changer for humanity. And as I will shortly tell you, it has created a new paradigm for humanity, of which we are all a part. And then how do we as lawyers, how do we as judges respond to the challenges which have been posed to us in a post-COVID society? I call it the post-COVID society in the optimism, and humanity survives on optimism that there would be no new variant of the virus which will come to us one day. But even if it did, I do believe that we are more prepared now than we were ever before. But I therefore think that there is something that COVID has done to us. It has produced, first and foremost, a digital marketplace where we've realized the importance of working within. We all live together, we work together, we survived in a marketplace of ideas together. COVID taught us that we could live isolated from each other. But is that a sustainable model? Or do we need to go beyond that by creating an agenda for sustainable development? An agenda for sustainable development in terms of the environment, an agenda for sustainable development in terms of our interpersonal relationships, an agenda for sustainable development in terms of the frameworks and the regulatory frameworks which we create as we move to a more sustainable future in our societies. When the Constitution was drafted, with which I began a short while ago, our Constitution makers had possibly no ideas of the lines along which humanity would evolve. We didn't possess notions of privacy. There was no internet. We didn't live in a world which was controlled by algorithms. And we certainly didn't have the social media. For every little thing that we do, and believe you me, as judges, we are no exceptions to this, because for everything that you do, you face the threat of being trolled by someone who doesn't share your point of view. We live today in an age where people are short on their patience and they are short on their tolerance. They are short on their patience, which is a reminder to me to be brief. But people are also short on the tolerance because we're not willing to accept perspectives which are different from our own. So just as humanity has expanded with the global advent of travel and technology, humanity also has retreated within by not willing to accept anything that we ourselves as individuals believe in. And I believe that's the challenge of our age. Some of this is perhaps the product of technology itself. Truth has become the victim in an age of false news. With the spread of social media, something which is said as a seed germinates into virtually a whole theory which can never be tested on the anvil of rational science. But the grave danger which our societies do then face is the danger of not being able to combat what we have now set forth, a change which humanity has brought in terms of the advent of technology, but which is perhaps flowing out of our control. But having put you on guard of the pitfalls of the world which we live in, let's also dwell on the positives as well. One of the great benefits of the age in which we live, the age of globalization, and now, with the problems which we have faced, the inward-looking localization, the need to promote local welfare, is the creation of an international rule of law, particularly in the commercial context. And our profession, the profession of lawyers, the profession of judges, has been a central focal point in generating the creation of an international rule of law. We have created an international rule of law by developing international instruments, as we did after the Second World War, whether it was in the context of the Convention on Civil and Political Rights, the Convention on Economic, Social, and Cultural Rights, and then, of course, a whole host of specialized conventions, whether it was the Convention on the Elimination of All Forms of Discrimination against Women, or the Convention against Torture, or the Convention against Racial Discrimination. And these conventions have therefore created an avenue for domestic jurisdictions worldwide to adopt an international rule of law and embody it within as a framework for an evolving domestic rule of law. So in that sense, it has given rise to the internationalization or the international germination of domestic law. At a certain level, we have looked at it from a comparative context. So for instance, in fields as diverse as whether we should have the right to privacy as a constitutionally protected right, or in more commercial context, such as the notions of fairness and equality and fair procedure in commercial arbitrations, we have embodied within our own legal framework international principles which were grounded in a broad framework of rights, certainty, and the legal aspirations of a just international order. But equally, there is a reverse trend which has been taking place, which is the constitutionalization of international law. Just as we have had international borrowings into the local context, we have had the export of domestic ideas into the international context. So what we have written within our systems has become a part of a wider international dialogue across continents and borders. We live in an age where there is a seamless flow of capital across boundaries. There has always been a movement of human beings across boundaries. Thousands of years ago, there were no political boundaries. Human beings could flow seamlessly across continents. As political boundaries grew, there were restrictions on human movement, but globalization produced the seamless movement of people. But above all, I think our age is marked by an internationalization of ideas. And this internationalization of ideas is truly something which holds hope for us as we emerge from the darkness which was cast upon us between 2020 and 2021 in particular. As I speak to all of you from our legal community, let me tell you about how technology has been transforming our lives in the profession which is so close to my life as a judge of the Supreme Court, namely the profession of judging. The COVID-19 pandemic gave us little option. The Chief Justice of the Supreme Court of India then spoke to me and said, "We have to pull down our shutters tomorrow. How are we going to ensure that we will grant bails to people who are in distress, who have been arrested? How do we ensure human liberty?" We had in place a robust technological infrastructure in nearly 18,000 courts in India. We had desktop computers in every courtroom. And I said to the Chief Justice that we have these desktop computers in every courtroom and we could just use them to start video conferencing. So we started some video conferencing in a very gentle way and then expanded it across all the courts in India. What video conferencing has done as a consequence of the pandemic is that it has led to a decentralization of justice. And I think this decentralization of justice is an important paradigm in promoting greater access to justice. Of course, at a certain level, it has promoted judicial efficiency. But it was also promoted a sense of equalization of social opportunities for advancement. The Supreme Court of India is not just the Supreme Court of Tilak Marg in New Delhi. The Supreme Court of India represents the aspirations of citizens in the smallest villages. And what better way to reach out to our citizens than to use technology as a part of our mission to take justice to the doorstep of citizens. So far from technology really being something very complex, the back end of technology as complex as it can be, but the front end of technology is something which we have to utilize to reach out to citizens, so that we reach out in terms of providing all our services. The colonial model of justice was premised on common citizens reaching out to justice. If you look at the architecture of our great colonial buildings of justice, these colonial buildings which provided justice during the colonial regime were intended to be architectural marvels, but they were also intended to wreak a sense of awe and fear in the minds of citizens. You would have a big silver mace which would be placed at the front of the desk of the judge, if only to remind the citizen that the power of this mace could be used on your life if you didn't fall in line. Now that model of justice has to change. Of course, those buildings are our heritage, but the model of justice which those buildings embodied in the colonial era has changed. We still operate a penal code of 1860. But while we operate the penal code of 1860, our interpretation of the penal code has changed. There was a very beautiful book written on the dissents of Justice Syed Mahmood, who was one of the very distinguished judges of the Allahabad High Court. The law in the British era was that if the accused was not present before the judge, it was yet open to the judge to decide the criminal appeal in the absence of the accused by reading the papers themselves. We then reinterpreted our criminal procedure code before the right of a hearing became a part of our law in the criminal procedure code of 1973 by interpreting it to mean that there can be no justice to the accused unless the accused is personally heard by the judge. And you cannot condemn a person to the gallows or for any term of imprisonment unless that person is heard. So we have changed through a process of creative interpretation the colonial model, as it were. And now it is for us as succeeding generations to use the benefit of technology and creative interpretation to reach out to our citizens. As part of our mission in the e-courts project, we are on the anvil now in the Supreme Court of making e-filing universal. Every case would be filed in the e-filing mode. Our e-filing module is undergoing a security audit, But we will have to train our own lawyers, our law clerks, the clerks of the lawyers, because there is an internet divide and we don't want anyone to be left behind in the advent of technology. We have launched into a very ambitious scheme for digitizing records across India in all our courts. We've already started live streaming court proceedings. Our Constitution bench hearings in the Supreme Court are live streamed. The benefit of live streaming is to reach out to citizens. On the flip side, citizens will realize how boring the processes of hearings in the court can be. But in telling them of how boring our work sometimes can be, we are sending out a message to our citizens that in the smallest cases which we decide, of somebody's pension, of somebody's job, of somebody's disability compensation, we take every little case seriously. And that sense which emerges, therefore, from the use of greater technology in terms of live streaming is to remind our citizens that we exist for you and to promote access to justice and to realize access to justice by involving the citizens in the participatory role as people for whom justice is truly intended. There are 30,000 judgments of the Supreme Court, 34,000 judgments of the Supreme Court since 1950. Each of these judgments was available in English in the official report, which was the Supreme Court report, which was woefully behind time. The result was that all the judgments of the Supreme Court were put across to the legal profession by private publishers who would use our judgments to create beautiful headnotes and then offer them for sale to our citizens. I have no difficulty with it because they did a great job. I've used those reports both as a lawyer as well as a judge. But what we have done recently is to digitize the entire 34,000 judgments of the Supreme Court. We've provided a free text facility, a search facility, and each of these 34,000 judgments is now available free of charge for citizens across India. You have law colleges in India which have no resources to purchase law reports. That's the harsh reality of India. We have at one end the brilliance of the national law schools, which sustain all the top law firms in the country, but we also have the base of the pyramid, where there are no books or no law reports. They have no resources. Now, there is, I believe, a duty on all of us as members of the profession to reach out to them. Because unless we reach out to citizens who are at the base of the pyramid, our mission as leaders of the profession would not really be fulfilled. And it is in that spirit that I mention these facets to all of you, to give you a sense of being sensitive to the issues which the large base of the profession faces. Apart from the e-Supreme Court reports, we've launched a new project to translate every one of our 34,000 judgments in every Indian language which is recognized by the Constitution. Already close to 3,000 judgments have been translated into Hindi, and these have been made available to our citizens. Now, our mission to translate judgments is guided by one object, that you must allow citizens who don't know English, and certainly not legalese English that we write and speak of in the courts, talking of ejusdem generis and actus curiae neminem gravibit, and so on and so forth. We have to allow our citizens to understand the work which we do in a language which is known to them. And we are using artificial intelligence and machine learning through a product which is being developed by the IIT, the Indian Institute of Technology at Madras, for the purpose of disseminating our judgments. Just last week, in the course of a Constitution bench hearing, we had real-time transcription of the arguments which were made by lawyers on all sides, including the learned Solicitor General. So the arguments which were made before the Constitution bench were reflected on a screen in the court real time. By the end of the day, the arguments were cleaned up, not cleaned out, but cleaned up. And then, once the lawyers had said that the arguments were fairly accurate, or completely accurate, we decided to open them up to the community. So this is a limitless source for people to understand legal strategy, to teach legal strategy to law students, to show them how constitutional cases are evolved in a court. What is the process of legal reasoning which our courts follow? Because the output of a judge, I do believe, is only a tip of the iceberg in what emerges as the ultimate product of the courts. We are moving into paperless courts, courts where there would be no paper at all. In fact, as a matter of fact, all of us, 5 judges in the Constitution bench, didn't use a scrap of paper. We were completely in a digitized format, and we had the entire caseload on our laptops. We have adopted virtual courts for dealing with traffic offenses, the smaller summary offenses, so that the work which was done by, say, 24 judges can be done by a single judge monitoring a server. Now, all these initiatives are crucial. For instance, what do virtual courts do? A shopkeeper who keeps their shop open beyond the regular hours and has to pay a paltry fine to an inspector doesn't have to waste a day to attend a court to pay the fine. Or somebody who wants to contest a traffic ticket doesn't have to go to court to pay the fine. All that you have to do is that you log on to the server. If you want to pay the fine, you pay the fine, and the case is struck off the cause list of pending cases. So technology in that sense enables us to reach out and to change the profile of the law as standing somewhat apart from the rest of society. But apart from technology, there are vital issues which confront the profession today. Chief among them is the reform of the legal profession itself. In so many ways, our profession is still patriarchal. Our profession is feudal. Our profession is built upon kinships and relationships of community, not to speak of closely monitored clubs of friendship, of association. The law firms in India were at the forefront of becoming equal opportunity employers. The reason for that was that when we generated the new national law schools, there was this inflow of highly talented young lawyers who had to be absorbed on a meritorious basis for employment. The law firms had a very valuable part in India in creating opportunities for women and men and others, and by giving them a level playing field to work on an equal footing, irrespective of parentage, of ancestry, of religion, of caste, of community. But that spread of equal opportunity is still to devolve on the mainstream, as it were, of the legal profession, of those who practice in courts. Seniors in our profession still don't believe that it's necessary to pay young lawyers proper wages. The attitude is that you've come to my chambers to learn. What do I pay you for? That model is really an obsolete model in the age in which we live. And unless we democratize the process of recruiting young people into law chambers in India, our profession will continue to remain feudal in its mindset, and we would not be open to allowing the truly brilliant minds to come into the legal profession. I'm often asked about why we can't have more women judges in the Supreme Court than we have. Or why can't we have more High Court judges from amongst the women that we have? And my answer is not simple. The answer is a little complex, but I hope it has a germ of truth. The state of our institutions today in terms of inclusion, of diversity, reflects the state of the profession, say, 2 decades ago. Because the judges who come into the high courts today, in 2023, or the judges who come into the Supreme Court in 2023, reflect the state of the bar at the beginning of the millennium. Now, unless there was a level playing field for women to enter the legal profession and to thrive in the legal profession between 2000 and 2023, there's no magic wand by which you will have more Supreme Court judges drawn from amongst the women in 2023. So we have to create a framework, a groundwork for a more diverse and inclusive profession today, if we truly have to create a future where our profession will be more inclusive and diverse. But there is cause for hope. Recruitment to the judiciary in India is drawn from the bar as to the high courts and, of course, to the Supreme Court. But recruitment to the judiciary in India is also drawn directly through the district judiciary into the higher courts. The statistics today on recent recruitments to the district judiciary in India at the lowest level indicate that in many states, over 50%, going up to 60% or more, are women. Now, the cause of that is a spread of education in India. As education has spread in India, women's education is caught up. And there is today a perception on the part of the middle class, the growing middle class in India, that the key to prosperity of the Indian family, the average Indian family, is to educate your daughters. Now, how do we convert that potential into promise? It's not enough that we have this young talent emerging out of our law schools into the legal profession. But how do we ensure that these young women don't fall by the wayside? Either because of the fact that their roles changed as life went on. Therefore, it is for us to create conditions of dignity in terms of the people we recruit into the legal profession. So I conclude by then saying that the importance of the conference which you have organized, and I thank the IBA for bringing this conference to India, is at various levels. It's about sharing best practices. It is about the spread of ideas. It's for creating interpersonal relationships. And I do believe that bringing this conference to India reflects the fact that India truly is a focal point today in the global marketplace, not just of business, not just of industry, not just about knowledge, not just about technology, but in the spread of new ideas. And when I hear statistics about startups, about unicorns, I think what's most important about that is the power of the young. Our country is reaping the demographic dividend. We are a young society. And in the young society that we have lies the prospect for hope that there will be change. So just as I began my lecture by telling you about some of the darkness which pervaded us just 2 years ago, I do believe, as an eternal optimist, that our society, the Indian society, would lead from the front as we aspire to be a more inclusive and diverse society. I didn't have my watch, and I am not sure whether I exceeded my time. Thank you very much.